Is the appellants prepared?
Yes, Justice, thank you.
You may begin.
Before I begin, I'd just like to confirm that my sound and positioning of the camera is acceptable to the court.
Yes, it is.
Okay, thank you. Good afternoon, Chief Justice and honorable members of the court. My name is Trang, initial J, and I am accompanied by my co-counsel, Aladina, initial S. Before I begin, I would like to first acknowledge and give the I present today the territory of the Mississaugas of the Credit First Nations. We rise on behalf of the appellant, Her Majesty the Queen, in the case at bar. Would your justices require a brief summary of the facts?
No.
Thank you. The appellant requests that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. The appellant has 3 submissions to make before the court today. Our first submission is that a member of an Aboriginal collective located outside of Canada does not qualify as Aboriginal Peoples of Canada under Section 35(1) of the Constitution Act 1982. Our second submission is that Mr. Desautel cannot establish continuity as per the Vanderpeek test. And our third submission is that there's a real threat to Canadian sovereignty if the constitutional protections of Section 35(1) are extended to include Aboriginal members located outside of Canada, as well as the appellant's proposed remedy in the case at bar. I will be addressing the first submission today, and my co-counsel will address the last 2. Members of the court, this case is about reconciling the relationship between Aboriginal and non-Aboriginal members of Canadian society who have lived and participated together as full and equal members. This is not about any other Aboriginal groups located outside of our borders. As agreed upon at the Supreme Court of Canada level, to determine whether Mr. Desautel has
Counsel, I'm going to interrupt you there. I think it's inappropriate to start your submissions on the basis that Indigenous and non-Indigenous people have participated fully as equal peoples in Canada over the last, well, prior to Confederation. So I want you to move forward from that statement and talk about how the process of reconciliation applies in the determination of whether or not Section 35 rights can be given to non-Aboriginal groups or non-resident Aboriginal groups.
Yes, certainly, Justice. A review of the jurisprudence in the constitutional provision can help us to understand that while residence or citizenship is not directly referenced in Section 35(1), it can be interpreted in this way. As the lower courts have noted in Vanderpeek, reconciliation is between, Aboriginal rights are only to be held by Aboriginal members of Canadian society. And furthermore, as found in Beckman and Little Salmon Carmacks First Nation, the grand purpose of Section 35(1) is reconciliation, but in a mutually respectful long-term relationship between Aboriginal and non-Aboriginal Canadians. The court specifically noted the need for a citizenship or residency requirement when looking at Section 35(1) because it is a provision that grants special constitutional protections to one part of Canadian society.
So, Counsel, what are you talking about? Is a threshold issue that residency as well as citizenship is what the threshold test is about?
Yes, we submit today that in order to establish if Mr. Desautel can claim the Aboriginal right, we must first answer the threshold question, which is whether or not citizens or non-citizens or residents can be Aboriginal peoples of Canada.
If I might interrupt, until 1965, registered Indians were not citizens of Canada. If that law had remained in place, therefore, nobody would have Aboriginal rights? Is that what you're saying?
Respectfully, Justice, we understand that the Indians and the Inuit and the Métis were possibly added to the wording Aboriginal peoples of Canada at a later time, but we submit today that because Mr. Desautel is not a citizen or resident of Canada, we cannot add to this Section 35(1) provision. We can only interpret it to understand that it requires a citizenship or residency requirement.
So let me give you a very specific example. My partner is a Mohawk from the Six Nations Grand River Territory. She was born in Buffalo. She's not a Canadian citizen. She's living in Buffalo. She's not a Canadian resident. Therefore, she has no treaty or Aboriginal rights in Canada by your interpretation.
Yes, because similarly to Mr. Desautel's case, as your friend, as you mentioned, your friend lives wholly in Buffalo and is a citizen and resident of Buffalo, she would not be able to assert treaty rights here, or sorry, constitutional rights here either.
Even though she's a registered Indian in a band in Canada. That's your position.
Oh, sorry, she was a registered Indian here. For your friend, we would say that because she is the registered Indian member here, she would be allowed to be granted the Section 35(1) rights, but only because it's rather than the, oh, sorry, you mentioned she's not a citizen of Canada, pardon me.
So the Indian Act creates constitutional rights then. It's not the Constitution.
I think what we're asking counsel is, if you're going to talk about a threshold test, you had better be sure that you understand the implications and the nuances of such tests. If the test is purely based on residency and citizenship, then it excludes individuals who are recognized members of a band in Canada, located in Canada, who don't have citizenship, who may not live within Canada, but are still recognized band members of groups within Canada. So we're asking, what is your threshold test? And if there are exceptions or other things that we should know, then you need to tell us in your submission.
Respectfully, Justice, we understand that there are members of Indian bands or Indigenous tribes that don't reside here in Canada, and we must acknowledge that with colonization came the formation of international borders and citizenship, and we must impose these requirements today in the Constitution Act 1982, specifically for Section 35(1), because we can only reconcile with members, Aboriginal members who are currently located inside of Canada, because they must be prioritized and focus on reconciling with them before we can get to other Aboriginal members outside of Canada.
Right, but weren't Aboriginal members outside of Canada also affected by colonization? I mean, why are we using this arbitrary distinction of who's north of the border and who's south of the border?
Yes, Justice, we do concede that Aboriginal members outside of Canada were also affected by colonization. But today we're submitting that the Crown's duty is only to reconcile with those who are inside of Canada presently. We are unable to reconcile with all of the Indigenous members outside of Canada, as a variety of policy implications may arise, as my co-counsel will submit, such as the constitutional conferences or duty to consult.
Okay, and I understand that there are practical considerations to be factored in, but right now we're looking at obviously the threshold level. And wouldn't you say that it is incompatible with an idea of mutual sovereignty for this essentially threshold test to be determined by two things, being permanent residency and citizenship or citizenship, both of which are essentially entirely controlled by the government of Canada? And so wouldn't that make it such that Canadian sovereignty is really the only consideration that
Oh, I think you put yourself
sorry.
on mute.
My apologies. And so yes, so meaning we have a mutual sovereignty that's supposed to be part of the proposed interpretation, but if it's determined by something that was done without the consultation of Indigenous peoples, how is that respecting mutual sovereignty?
Yes, Justice, so we understand that we need to strike a balance between our interpretation of Canadian sovereignty as well as our Indigenous people's version of their sovereignty. And we submit that when we're looking at Indigenous sovereignty, we're only looking at Indigenous members that are wholly located inside of Canada at the time of the claim.
But why is it at the time of the claim? Isn't this supposed to be a backward-looking exercise into what their practices were historically and at the time of contact?
Yes, Justice, we understand that the Constitution Act in 1982 didn't create Aboriginal rights, it merely elevated them to constitutional status. So we acknowledge that there are many practices, customs, and traditions that the Indigenous peoples had prior to 1982, but with the creation of the Constitution Act came the need for us to impose a citizenship and residency requirement, because at that point, Canada was a sovereign nation and could not accommodate to all Indigenous peoples, only those that we can reconcile with inside of our borders.
Okay, but Counsel, you would acknowledge that there is not written in the Constitution that there be a residency or a citizenship requirement. And furthermore, that none of the documents or supporting evidence in the drafting of the Constitution ever talked about or considered Indigenous groups residing outside of Canada.
Respectfully, Justice, we do understand that residency or citizenship wasn't explicitly stated inside Section 35(1), but we do submit that the drafting history should be taken into account, much like the minutes of proceedings discussion that was used regarding Canada's patriation.
And how do you reconcile the French version in comparison to the English version, where the French version du Canada can essentially mean from Canada, as opposed to of Canada, which are two very different potential implications. So how do you, and in case law, sometimes the French interpretation has made all of the difference in terms of how things are interpreted. So how do you reconcile the English versus the French interpretation of the Constitution?
Yes, certainly, Justice. So when we look at the French translation of Canada, what you said would translate to from Canada, we still submit that Mr. Desautel is not from Canada himself. His ancestors were, which is why we submit today that he cannot claim the rights, Section 35(1) rights of the Constitution. And when looking specifically at of Canada, of typically means that the person dwells at the place named, which in this case was preceded by the geographical location Canada.
But does it even, I mean, even if we take even the English side of it, of Canada, that's an ambiguous term. I would submit that it's equally plausible that it means, again, from Canada or originating in Canada. Does it not?
Justice, while we do understand of Canada can carry a variety of different meanings, we submit that today, in the context that it was used, of refers specifically to someone that's dwelling at the place of that was named, such as Canada in this case. And it was also similarly used in other sections of the Constitution, such as Government of Canada and Official Languages of Canada, where a geographical qualifier was imposed in the meaning of.
Okay. Okay. I was going to say, Counsel, you do understand, though, that the Constitution and all of this talk about drafting, it is a living, breathing document. And you would acknowledge that jurisprudence and direction from this higher court has said that reconciliation and interpretation of Section 35 should be given extraordinary consideration in terms of how its interpretation affects Indigenous rights in pursuit of reconciliation. So should we not interpret it in the way that it should be done now, and understanding what we do now as opposed to in 1982?
Yes, Justice, I see that my time is elapsing. May I answer your question and briefly conclude?
Please do.
Okay. So as noted in Mitchell at paragraph 135, reconciliation is between those who have lived and participated together in a shared Canadian sovereignty. And it is found that groups outside of Canada who do not contribute to our national diversity or work as a collective governance with other Canadians cannot be considered Aboriginal peoples of Canada. Honorable Justice of the Court, it is clear that Section 35(1) of the Constitution Act of 1982 was never meant to include Aboriginal peoples located outside of Canada who are neither Canadian citizens nor residents. We cannot broaden the constitutional protections of Section 35(1) to Indigenous groups outside of Canada, as this would be a devastation to the Indigenous groups currently located in Canada who require our reconciliation and a long-term respectful relationship. And for these reasons, we ask that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. Barring any further questions, my co-counsel will now address the last two submissions.
Thank you.
Thank you.
Justices, before I begin with my submission, I would just like to apologize and inform you that I will not be able to stand today. I do have an accessibility accommodation, if that is all right with the court.
That's perfectly fine,
Thank
counsel.
you. May I proceed?
Yes.
Thank you. Good afternoon, honorable justices of the court. My name is Alidina, initial S, and I rise to conclude submissions on behalf of the appellant, Her Majesty the Queen, in the case at bar. Before I begin, I would like to first acknowledge and give respect to the land on which I present today, the territories of the Wendat, the Anishinaabe nations, and the Haudenosaunee Confederacy. The appellant's second submission is that Mr. Desautel cannot establish continuity as per the Van der Peet test. And our third and final submission is that there are very real and significant threats to Canada's sovereignty by extending the constitutional protections of 35(1) to include Aboriginal groups located outside of Canada, and that the appellant's proposed remedy is one to enter a verdict of guilty on both counts contrary to the Wildlife Act and remit the matter to the trial court for sentencing. Justices, it is the appellant's position that the Van der Peet test for an Aboriginal right under Section 35(1) is not satisfied in this case, because the trial judge committed a reviewable error in her application of the Van der Peet analysis, finding that the continuity requirement was met. While the appellant does concede that an unbroken chain of continuity is not required, we do submit that the flexibility of the interpretation of continuity has its limits. In the case at bar, the limitation that has been crossed is one of a lack of evidence. The only evidence offered at trial about the Lakes tribe's presence in British Columbia at all before 2010 was a singular event in 1972, when Charlie Quintiskett, a Lakes Indian from the Colville Reservation, walked into the office of Aboriginal scholar Dr. Dorothy Kennedy to ask why the Lakes people had no reserves in Canada. Not only does this have no legal significance.
Counsel, I'm going to stop you there. I just want to clarify, you're referring to since perhaps Confederation or since a certain date, because I don't think it's disputed in any way that the Sinixt people were actually there at the time of European contact.
Yes, Justice, we are submitting that this piece of evidence is the only evidence offered about the presence in British Columbia of the Lakes tribes before 2010, when Mr. Desautel fired a single shot to kill the cow elk.
Well, wouldn't you agree, though, that somebody going into an Indian Affairs office, presumably in 1970, indicates that the land in British Columbia was still in the hearts and minds of the Lakes tribe in terms of their connection to British Columbia as part of their traditional migratory hunting grounds?
Absolutely, but the appellant's position is that the fact that the Lakes tribe maintained a connection to the claimed right in their hearts and minds is an incredibly low evidentiary standard to set. Now, our friends will likely submit that the creation of the international border and the outlawing of hunting by British Columbia through the Game Protection Amendment Act of 1896 explains why the Lakes tribe gradually ceased hunting in Sinixt traditional territory. However, the trial judge held that the Sinixt had continued to hunt in British Columbia up until the 1930s, despite the passing of the 1896 Act. And for that reason, it cannot be said that either pieces of this legislation prevented the Sinixt from hunting. But
well, I mean, they were breaking the law in the process. And so how is that consistent with the honor of the crown to say that ends up breaking up the continuity when there was an act passed saying that this was illegal? And so is the Crown's position that the only way that they could establish continued practice would be through a violation of not only that law, but also the border, the international border?
The appellant's position is that continuity could not have been established through legal action, but that a single shot could not create the Lakes tribe's modern exercise of the right. And in the absence of even minimally cogent evidence, this conclusion is inescapable.
Can you please explain how that's consistent with the honor of the Crown argument? If the Crown itself has taken measures to prevent this continued access to the land and continued access to the land for hunting purposes specifically, wouldn't the honor of the Crown obligate this court to take into account those factors and whether or not that was really, I guess, a lack of continuation by choice?
Absolutely, Justice. First, and may I have a moment to consult my notes?
Absolutely.
Thank you. As following, similarly to the principle of construction in Aboriginal perspective, where deference is owed in any case of ambiguity, the appellant's submission is that we cannot, the Aboriginal perspective and this principle does not tell us if we should only affirm those rights of citizens or residents or of peoples like Mr. Desautel as well, who in the appellant's position are not considered Aboriginal peoples of Canada.
Counsel, I'm going to jump on that here and point you to paragraph 65 of the Vanderpeet case, because I'm a little bit troubled by this rigid application of continuity. It doesn't seem consistent with what Vanderpeet has said in terms of broken chains of continuity as they describe it.
Absolutely. Justice, while the appellant has conceded that an unbroken chain of continuity is not required, and in addition to that, that it is not unusual for the exercise of a right to lapse for a certain period of time, we do submit that it is our submission that this has been, the modern exercise of the right has not been established. And for that reason, the appellant's position is that the rights in the land have been abandoned.
Okay, and so you say abandoned, even though in 1970, there was concern about why the Lakes tribe did not have any rights in British Columbia, and the fact that Mr. Desautel came into the territory to exercise and assert his Section 35 rights.
Yes, it is our position that Mr. Desautel's single shot did not create the modern exercise of his right, and continuity was not verified by that incident.
I'm going to go back to paragraph 65 of Vanderpeet. Trial judges should adopt the same flexibility regarding the establishment of continuity that they are to regard the evidence. And so a trial judge has made that determination in this case. What you are asking this court to do is overturn and overrule the trial level court's determination of that finding. Why should we be interfering with that decision?
Certainly, Justice. While the trial judge is owed deference, the appellant's position is that the facts as she found them do not meet the continuity requirement necessary to establish that Aboriginal right. Furthermore, if I can refer you to paragraph 39 of Mitchell, the Vanderpeet approach does not operate to amplify the cogency of evidence adduced in support of an Aboriginal claim. Placing due weight on the Aboriginal perspective or ensuring its supporting evidence in equal footing with more familiar Western forms of evidence means precisely what these phrases suggest: equal and due treatment. So while the evidence presented by Aboriginal claimants like Mr. Desautel should not be undervalued, neither should they be artificially strained to carry more weight than they could reasonably support. And it is the appellant's submission that the evidence that Mr. Desautel has presented and that the trial judge affirmed has been strained artificially to carry more weight than it can reasonably support.
So is what you're saying that the rights can exist, but in this case, they just haven't been sufficiently proved?
Yes, Justice.
Counsel, I don't know that the jurisprudence supports your argument, so I want you to move on.
Okay. This brings me to my final submission. Justice is failing to adopt a purposive interpretation of Section 35(1) leads to implausible and problematic results that are threats to our nation's sovereignty. Extending the constitutional protection of Section 35(1) to include—
Sorry, Counsel, how is it a threat to Canadian sovereignty to have a small number of Indigenous people engage in ceremonial hunting? Let's be clear here, ceremonial.
The appellant, our friends will, similarly to you, Justice Red-Eye, our friends will likely be of the position that while Aboriginal communities outside of Canada can assert and hold 35(1) rights, it does not follow that their rights are the same as communities within Canada. However, the appellant's position is that this could not be more untrue. If an Aboriginal group outside of Canada is entitled to exercise 35(1) rights then in Canada, then it must have equal protection under the Constitution and be able to access and exercise a full panoply of rights in the same fashion as Aboriginal rights holders within Canada. And nothing less would uphold the honor of the Crown and further Canada's ongoing process of reconciliation with its First Peoples.
So what
you were just saying, that we do this on a case-by-case basis based on the evidence. And so if the evidence isn't there on those other claims, then those types of rights wouldn't emerge, right? I don't see how we reconcile those two positions.
The appellant's position is that a multitude of challenges would arise as a result of this decision, as a result of favoring our friend's position with respect to the Crown's duty to consult, where accommodating the interests of 35(1) rights holders outside of Canada may run counter to accommodating the interests of 35(1) rights holders within Canada. Aboriginal groups outside of Canada would be, in fact, implicated to the same degree, and for that reason, the Crown's duty to consult could not differ unless a two-tiered consultation process were established, which would run afoul to its obligation to engage in a process of fair dealing and reconciliation, which is cited directly in the 2004 case of Haudenosaunee Nation in British Columbia.
I don't understand, Counsel. At this time, in this day and age, we have all sorts of technological means. We have all sorts of ways to conduct consultation. Many Indigenous people claim that duty to consult isn't even done properly now with Indigenous groups in Canada. I highly suspect that Canada in and of itself is not upholding its obligations in terms of duty to consult. So tell me how a two-tier system would be operating with Aboriginal groups outside of Canada, because right now it seems like all of our groups in Canada are suffering on a third tier anyway. So tell me how.
Before I answer your question, my time is elapsing. May I answer your question and briefly conclude?
Please do.
Thank you. The appellant agrees with you completely. The Indigenous peoples, Aboriginal peoples of Canada are already struggling with the Crown's duty to consult, with reconciliation. These are the people who live, work, and feel the full burden of our law, unlike Mr. Desautel. And it is the appellant's position that for that exact reason, we should take the position of favoring, my apologies, not favoring, but reconciling and taking the opportunity to reconcile with the Indigenous people and Aboriginal peoples of Canada who have that status and who do feel the third tier already.
So just to confirm, because Canada's doing a poor job right now in terms of its obligations to Indigenous groups in Canada, you're saying they shouldn't be extended to do an even poorer job with groups outside of Canada?
We cannot deny our colloquial government and the aspects of colonialism that have still not been repaired in our institutions. But the appellant's position is that we must focus on making reparations with those who right now feel the full force and full pain of colonialism in this nation. Honorable Justices, while we cannot agree with these colloquial borders, we cannot deny that they exist and their importance in today's day and age. We cannot deny the importance of citizenship and residency. And for that reason, to side with the respondent's position would be to turn a blind eye to the fact that Canada is a sovereign nation and that we must look after those and protect those who work, live, and feel the full burden of our law. Barring any further questions, the appellant rests.
Thank you. Are our respondents prepared?
Sorry, just a moment to transfer to my standing setup.
When you're ready.
Thank you, Justices. My apologies. Thank you, Justices. My name is Navya Sheth, and I am here with my colleague, Leisha Shah, on behalf of the respondent, Mr. Richard Lee Desautel, in the case at bar. It is the respondent's position that the Supreme Court of Canada was correct in finding that Mr. Desautel is a member of the Aboriginal Peoples of Canada with a right to hunt under Section 35 of the Constitution Act. Indeed, we posit that constitutional interpretation should be generous in order to acknowledge the unique harms done to the Aboriginal peoples of Canada through systems of colonization and to promote the objective of reconciliation. To this end, the respondent has two submissions to make today. The first submission, which I will address, is that a purpose of interpretation of Section 35 includes protection for modern successors of those Aboriginal peoples who were on the land at the time of contact. Our second submission, which my colleague will address, is that there is sufficient evidence to establish a right to hunt under the Vanderpeet analysis for Mr. Desautel. In light of these two submissions, we respectfully request that the Supreme Court of Lions Cup dismiss this appeal, exempt Mr. Desautel from sections 11.1 and 47A of the Wildlife Act, and uphold his acquittal. To begin with the first submission, it is the respondent's position that the majority and the dissent at the Supreme Court of Canada, the majority at the Supreme Court of Canada were correct in turning to the past jurisprudence of the court in order to determine the purpose of Section 35. As the court found in the 2020 case of Newfoundland and Labrador and Anishinaabe, defining Section 35 rights is a task that has fallen largely to the courts, and therefore the principles arising from that jurisprudence should be determinative of Section 35's purpose. Our friend's position that Aboriginal peoples located outside of Canada may not access Section 35 rights is inconsistent with the principles that arise from this jurisprudence. Our friends have cited the 2010 case of Beckman and Little Salmon Carmacks First Nation as evidence of a grand purpose of reconciliation between two groups within Canadian society. However, Justices, I'd like to distinguish that case as it was one of treaty claims. And as the court found in the 1996 case of the Queen and Badger, treaty rights differ from Aboriginal rights in both origin and structure. That is, treaty rights arise from written agreements between two parties, whereas Aboriginal rights originate from historic occupation and practice on a specific tract of land, which is then articulated as a modern right within the Canadian legal system. It is our position.
Counsel, would you not agree, though, that there is some concern that the court should feel and consider in terms of once Aboriginal rights are given, that very soon Aboriginal groups outside of Canada could also move further to try and establish more rights, including title rights and possibly even treaty rights that were violated. So what is your position and submission on that?
Respectfully, Justice, it is our position that the Honour of the Crown suggests that those Aboriginal people should be provided an avenue to make those claims. Nevertheless, we are not afraid of a floodgate, such as our friends have suggested, because once the threshold has been crossed, there is still the requirement of the Vanderpeet analysis or the Delgamuukw title analysis to surmount before Aboriginal peoples outside of Canada can establish a right to land within Canada. And as a result, it is our submission that those Aboriginal peoples who have historic links to the land must be given the status of Aboriginal peoples of Canada under Section 35.
Counsel, I have a concern about the future implications of the decision that we'll be making based on your submissions today. Namely, as a U.S. citizen or U.S. citizens such as your client don't have a right to enter Canada under the Charter. So wouldn't that run contrary to granting Section 35 rights to non-residents or non-citizens?
No, Justice. It is our position that as the mobility right was acknowledged at the Supreme Court of Canada to be incidental to the right to hunt and therefore not implicitly connected, the granting of a right to hunt does not immediately imply a charter protected mobility right. What is at issue is the question of a right to hunt, and therefore there is no issue of a charter mobility right in this
Right,
case.
but if an individual is denied entry into Canada as a result of not having mobility rights under Section 6, but they have a Section 35 right, how could we ensure that that Section 35 right is guaranteed?
Respectfully, Justice, in such a circumstance, an Aboriginal person could apply to the courts in order to ensure that their ability to enter Canada is protected. However, Aboriginal peoples of Canada are eligible under Section 35 to Aboriginal rights. And in this case, that does not include a mobility right and should not be considered as an impediment to Mr. Desautel's Section 35 right to hunt in the case at bar. Additionally, Justice, I'd like to refer back to a comment made.
Before you move on, I want to take you back to a case you mentioned, Badger, because I think it does raise some interesting questions about treaty rights. And in paragraph 78 in Badger, the court states that the honor of the Crown is engaged through its relationship with the Native people. This is it not what Section 35 is all about, the relationship between the Crown and the Native people that are involved? And if we're talking about Native people at a time when the Crown didn't exist or the country didn't exist, how are we then having this relationship with people we're making a new relationship here, are we not?
Respectfully, Justice, it is our position that there is an existing relationship between the Crown and the Sinites, as several of the justices on this panel have referred to. The Game Act of 1896 was an explicit act on the part of the Crown to restrict the rights of Aboriginal peoples. And in fact, the particular group of Aboriginal peoples that are claiming a right before this court today. And indeed, the honor of the Crown, justices, also requires an interpretation of Section 35 that is generous and purposive, per Uashinuit. And interpreting the provision to include Aboriginal people.
Let's just unpack this a bit. The 1896 law then, in your submission, effectively terminated those hunting rights, did it not?
No, Justice. It did not terminate those hunting rights.
At the time, because there was no constitutional protections, it terminated in common law those hunting rights, did it not?
No, Justice. It terminated those hunting rights for a specific relationship in terms of those who were not residents could not hunt. It did not explicitly exclude the Sinites from hunting, but it was an implicit action on the part of the Crown in order that was discriminatory to a specific group of Aboriginal peoples.
So what you're saying is that the relationship between the Crown and the folks living on the American side of the line is defined by an assault by the Crown upon them? That's a relationship. I just don't like it much.
Absolutely, Justice, and neither do we. And as a result, we are asking today that the Crown act in order to remedy that relationship by granting these people the status that they have so long been denied. In fact, our friends have submitted that the Lakes tribe are unable to claim rights under Section 35 because they are not part of a shared sovereignty as members of Canadian society. We'd like to remind this court that in fact, the Lakes tribe are not part of Canadian society because their removal from the country was not voluntary. And as Justice Turkanu has pointed out, the Lakes tribe was also significantly impacted by colonization, not least through their forced displacement. And
so I have a question, Counsel. So can you tell me how we would reconcile Indigenous groups who have rights within Canada already, and if we allowed these floodgates, quote unquote, open, how would we reconcile rights that Indigenous groups already have in Canada if they're affected by the assertion of Section 35 rights by groups outside of Canada? How would we reconcile and deal with those types of issues?
Justice, it is the groups that are already in Canada, it is our position, it is not our position to contest that those groups in Canada do have constitutionally protected rights. However, we do have internal regulatory frameworks that can manage the differences between rights claims for groups. For instance, the very Wildlife Act, under which Mr. Desautel was charged, has as part of its mandate the goal of regulating Aboriginal peoples and protecting their rights to hunt within British Columbia. And it is our position that as Aboriginal peoples of Canada, the Sinaics can be incorporated into such regulatory frameworks. And as the court found in Powley, difficulty should not be an excuse for denying people's rights. And therefore, it is our position that groups such as the Sinaics, to exist outside of the border, can have their rights reconciled with those who live within the border. Justice Kasper, to also return to something you've mentioned to our friends, the Constitution is in fact a living document, and our friends' citation of the minutes or the intent of the drafters does not actually contemplate the new reality that is before the court today. And it is the judiciary's role as the guardian of the Constitution.
Counsel, what's the new reality? I think the submission that I heard is that this is a very old relationship and a very old practice. So if anything, again, in 1982, the framers of the Constitution would have known that there would have been peoples that were displaced from Canada into the US, and that could have actually emerged. And so they constructed it in a very specific way. Is it something new or is it something old? Which one is it?
It is an old practice, Justice, which is for the first time appearing before the Supreme Court of Canada in a position where the court can make a determination on the meaning of Aboriginal peoples of Canada. And as you rightly pointed out, the framers of the Constitution were very selective with their words, and they could have chosen terminology that explicitly excluded Aboriginal peoples who lived outside of Canada. But they chose not to do that, Justice. And it is our position that the linguistic context should be read to import the historic importance and occupation of Aboriginal peoples on the land. That of Canada is not frozen in time in 1982 or in the present day, but rather looks back to being of Canada since time immemorial. And that, Justices, is consistent with Aboriginal jurisprudence on the matter. The tests of Vanderpeet and Delgamuukw both look back to historic occupation and practice, and then articulate those as modern rights. It is our position that a threshold test for Section 35 should take a similar structured approach as the other tests under Section 35 for Aboriginal rights.
Counsel, what would be your suggestion in terms of the threshold test?
Our suggestion would be to look back to the Aboriginal peoples who lived on the land pre-contact and at the time of contact, and to have a successorship requirement to be qualified as an Aboriginal peoples of Canada, so as not to exclude those peoples who may have been forcibly displaced or displaced due to factors beyond their control. And it is our position, I would just add, as the majority did, that this should not exclude the Métis peoples, as they have a unique origin and therefore should not be considered to have exactly the same successorship requirements, as they did only arise post-contact. Justices, the Lakes tribe, as a peoples of Canada, was existing on this land pre-contact and at the time of contact. And indeed, for many decades after contact, they continued to occupy and practice on the lands that became Canada. They were forced out of Canada due to factors that were beyond their control, a constellation of factors that included, as my colleague will touch on, tensions between the Lakes tribe and settlers, as well as economics factors and the residential schools and other factors of colonization, including their ban on hunting. Aboriginal rights are not frozen in time, Justices, according to Mitchell, and a modern day residency requirement would ignore the historical origins of Aboriginal rights and freeze them in the modern day. Since the Lakes tribe is accepted to be a successor group of the Sinaics, and the traditional territory of the Sinaics at the time of contact extended into British Columbia, the land and the Lakes tribe and Mr. Desautel are Aboriginal peoples of Canada. I see my time has almost elapsed. If I may briefly conclude.
Yes.
Thank you. Justices, in the case of the Queen and Badger, Justice Corey, as Justice Harada has highlighted, said that Aboriginal rights flow from the customs and traditions of the Native peoples and embody the right of Native peoples to continue living as their forefathers lived. We ask that this court remain true to the purposes of Section 35 and uphold Mr. Desautel's right to hunt as his forefathers hunted. Barring any further questions, this concludes the first submission on behalf of the respondent. My colleague will now address the second submission. Thank you.
Thank you.
Good afternoon, Justices. My name is Laisha Shah, and I will be concluding the final submission on behalf of the respondent, Mr. Richard Lee Desautel, in the case at bar. It is our position that the majority was correct in their application of the Vanderpeet analysis, and the evidence is sufficient to meet the test. Our friends have submitted that there is insufficient evidence, and there is an error in finding a fact. We would like to clarify that there is an incredibly high threshold for finding an error in finding a fact, and as every lower court has agreed upon, deference is owed to the trial judge. Today, our friends have reiterated their submission, so far rejected at every level of court, that the present-day collective must be geographically continuous with the historic collective to be able to exercise rights under Section 35, which plays a role in the latter two stages of the analysis. The lower courts rejected this submission, holding that the Vanderpeet test has never included such a requirement, and to do so would ignore the Aboriginal perspective, the realities of colonization, and do little towards achieving the ultimate goal of reconciliation. Now, before I proceed with the Vanderpeet test, I would like to address the concern raised by our friends about how the imposition of the Border and the Game Protection Act was not a barrier to the Sinaiaks hunting on their ancestral territory. We implore this court to push back against this inappropriate characterization. Respectfully, Justices, illegal activity should not and cannot be the standard. This would further frustrate the access to justice issue Aboriginal peoples of Canada already face. They are continuously forced to go to court to protect and defend their Aboriginal constitutionally protected rights, such as in the case at bar, which arose to the Supreme Court of Lions Court within the context of a regulatory offense. Justices, this is inconsistent with reconciliation and would perpetuate the historical injustices which displaced these groups to begin with. We implore this court to keep this in mind when applying the test. And I want to turn to the test now. Although continuity is a part of the test for Aboriginal rights, as set out in Vanderpeet, it relates to continuity of practice and not continuity of community or practice in a specific geographical area. The test requires that a claimant demonstrate the historic and ongoing exercise of the right by the group in question, not
Right,
with.
and I think that's exactly where you run into trouble, isn't it, Counsel? I mean, it does not appear on the record that there has been hunting on those lands for 80 years, give or take. So where is the evidence of the right being exercised continuously?
Justice, the point we bring to the court is that the Vanderpeet test does not impose such a requirement. And so the courts in the cases which impose such a requirement came at a time where they were not likely able to fully comprehend the full effects of colonialism. Today, Justices, it is 2021. Over 2 decades later, we are now able to understand much further the importance of the Indigenous perspective, the realities of historical injustices faced by Indigenous groups, which barred them from practicing on their lands to begin with. I would also like to make note for this court that the lands on which the Lakes tribe practiced on, which is what is now Washington, is the same tract of land on their ancestral territory, stretching to what is now BC. And so even if this court were to impose the site-specific requirement, the integrality and continuity elements in the respondent's position would be met. However, no such requirement was established in Vanderpeet. In fact, in the case of Adams, the Supreme Court of Canada specifically noted that Aboriginal peoples moved their settlements both before and after contact. It was emphasized that wherever they settled, what is necessary to prove an Aboriginal right is that prior to contact, the Aboriginal people engaged in practices, customs, and traditions on that land, which were intended.
Counsel, so I just have a question. So you've said clearly a lot about the history of these people in terms of their acting against laws with respect to hunting and wildlife, which means that for the government of Canada, there has been continued concern about management of wildlife and management of hunting since the late 1800s. So And yeah, Mr. Desautel was charged under a act to limit hunting. So we're talking about theoretically areas where there's a lot of concern about resources and depletion of resources. So tell me how, allowing non-resident Indigenous groups to access these lands, in addition to people who already live here who are Indigenous, how do we resolve the potential issues there in terms of resource management and making sure that we are also protecting the wildlife that we have within that area?
Justice, to answer your question, I'd like to refer to my colleague's submission. And as Mr. Desautel and the Lakes Tribe are members of the Aboriginal peoples of Canada, they are also included to the right to these resources which are on their ancestral territory. And this would not be an issue before the court because there are only a finite number of individuals who are able to prove this ancestral connection. And so this would not create a floodgate or an issue with managing wildlife resources beyond what we already manage presently. And so to restrict the exercise of an Aboriginal right to an area of an Aboriginal person's present day community as advocated for by our friends would result in further injustice and would be inconsistent with the goal of reconciliation. It would be equivalent to finding that the Crown can extinguish Aboriginal rights through policies and practice that displaced Aboriginal peoples who lived in that area where the right was historically exercised. Under the approach of the lower courts, proof of ancestral connection and continuity of practice will suffice to connect a contemporary collectivity to a historical rights-bearing group. Such a requirement would essentially result in a small spots approach to the exercise of an Aboriginal right. Such an approach was soundly rejected by the Supreme Court of Canada in relation to the Aboriginal title, and it should not be adopted in relation to Aboriginal rights. Our friend's interpretation could preclude many wholly Canadian Indigenous groups with histories of displacement, including involuntary displacement, from vindicating their Section 35 rights. And if by the vagaries of history, an Indigenous group's present-day community is geographically dislocated from the primary territories of the historic collective from which it descended, it may be incapable of asserting rights, even if it has met all the judicially settled requirements of the Vanderpeet test.
Counsel, so as far as the federal government is concerned, it appears that their understanding is that the ancestral group was effectively extinct. They were no longer no longer on the land as they once were. So I wonder for the future, how would accepting your position affect the Crown's duty to consult? How would they be able to effectively discharge that duty moving forward when they may not even know that there's a group on the other side of the border that would have a claim to a certain tract of land?
I'd like to answer your question in two parts, Justice. First, in the case of Bar, the Lakes Tribe is not extinct, or the Sinai's is not extinct. They carry on in what is the Lakes Tribe in Washington today, and that's been proven through the facts of the case. And secondly, they were displaced involuntarily. And so to address the duty to consult, there is the option for them to self-identify.
A lot of submissions about deference to the findings of fact on the record by the trial level decision. There was never a finding that there was a forcible removal at any point, right? I mean, there were some incidents of violence and obviously tensions between communities, all of which was very common in the 19th century, but no, they were never forcibly removed. Isn't that correct?
That is correct, Justice. However, it was not voluntary. There was a constellation of factors. And while some may have benefited them, there are overwhelming factors that indicate that this was not a voluntary move and was in fact due to the forces of colonialism. In fact, if I could refer your Honor's attention to paragraph 101.
Counsel, I'm just going to interject. So is there any difference in terms of the threshold test if it was a voluntary move by another Indigenous group, if they were in Canada and there's a situation that they chose to move outside of Canada's borders, Is there any difference in terms of how a voluntary move outside of Canada by an Indigenous group should be considered in the context of trying to assert Section 35 rights?
No, Justice, it is our position that that would not make a difference. What is necessary, as my co-counsel has submitted before the court, is that prior to European contact, they resided upon that land, their ancestral territory, which is what is now Canada. And so now to address the duty to consult, our friends, as well as your justices, have raised, Aboriginal groups residing outside Canada are not implicated to this process in the same degree. And the duty to consult still comes from the honor of the Crown. So it still mandates that we enact this consultation. And while the consultation process may be more difficult when it involves groups residing outside Canada, the Supreme Court of Canada has established in the case of Powley that this does not excuse the Crown from consulting with these groups for the reason that it is difficult. Further, Aboriginal groups and communities are not uniform.
Right, so I'm going to pause you again there, Counsel, because we're trying to understand constitutional obligations. And so in your submission, then, if a constitutional obligation becomes difficult, I think was your word, then the Crown no longer has that obligation. Is that really what the submission is?
My apologies, Justice. Allow me to clarify. What was established in Powley was that just because incorporating groups residing outside of Canada may pose a greater challenge than simply those residing within, this does not excuse the Crown from consulting with them for the reason that it is difficult. And so we must still include them in the consultation. Now, to address our friends' concerns on the two-tier consultation, as I've submitted, Aboriginal communities are not uniform, and each community has different circumstances and are all implicated to a different degree. And so this is something we already deal with as it presently stands. To apply the Vanderpeet test in the way advocated for by our friends would yield the very result the Supreme Court of Canada warned against in Vanderpeet itself. It would be entirely contrary to the spirit and intent of Section 35 to define Aboriginal rights in such a fashion so as to preclude in practice any successful claim for the existence of such a right. Now, our friends have also referred to the 80-year temporal gap since 1930. However, if we turn to the trial judge's reasonings, at paragraph 101, it states that the Sinaiaks people felt unwelcome in what is now BC. And there are instances where there are gun violence and tensions between the Lakes tribe and the settlers. To ignore the realities of historical injustices that first displaced the Indigenous peoples and continues to bar them from practicing on their ancestral territory would also ignore the Indigenous perspective, which this court has underlined as important in the determination of Section 35 rights. Justices, to conclude, I would like to recite testimony from the trial judgment. It states, and I quote, "When I learned I was a Lakes Indian, it just runs chills up and down me that I can be where my ancestors were at one time and do the things that they did. When I come up here, I am walking with the ancestors. And it doesn't matter what people say. The truth is, this is where we are from. We never left this river. We never left this water. Even being a part of the Confederation of Tribes, we are Sinaiaks first. And all I can say is this. Justices, this is a beautiful moment in the movement of reconciliation for the Sinaiaks and for the country, and Mr. Desautel himself, that paves this pathway once and for all. For these reasons, we implore to finally fulfill the promise of reconciliation and uphold Mr. Desautel's acquittal. Thank you.
Thank you.
Thank you. I think we can stop the recording now.